There are a bunch of new laws that apply to Michigan families as of April 2, 2025. This especially impacts unmarried parents, same-sex couples, and couples who use a donor or surrogate to become parents. I'm Jim Kraayeveld, and I've been practicing family law in Michigan for over 30 years. And I want to talk about a bunch of new laws that just went into effect. There's first the Michigan Family Protection Act, the acronym MFPA. Second, there's the Acknowledgement of Parentage Act, also with the acronym of APA. There's the Revocation of Paternity Act, or now called the Revocation of Parentage Act, or ROPA. Fourth, there's the Genetic Parentage Act, or the GPA. Fifth, there's the Summary Support and Paternity Act, or SSPA. And lastly, and this is fairly a big change, is the Assisted Reproduction and Surrogacy Parentage Act, or ARSPA, ARSPA. Now, starting out with the MFPA, the Michigan Family Protection Act, is the all-encompassing initial act, and it's a new law that was part of 9 bills that were introduced and passed in 2024 that are going into effect on April 2, 2025. The Michigan Family Protection Act is to protect families. One of the biggest things that it does is it revoked the existing Surrogacy Parentage Act that didn't allow for paid surrogacy agreements in Michigan. It's now updated the assisted reproduction laws in Michigan, and it's adjusting all of the state laws to have them align with the U.S. Supreme Court decision of Obergefell versus Hodges, which stands for the position that same-sex spouses should be treated the same as heterosexual couples. The MFPA also has provisions updating things about paternity, and the big one is about surrogacy. So I want to discuss those next. There are 2 big ones. The ARSPA, ARSPA, or Assisted Reproduction and Surrogacy Parentage Act, replaces the old law in Michigan that was passed by the Michigan legislature in 1988. That law made surrogacy agreements void and unenforceable and made it a felony for anybody that participated for compensation. So let's talk about surrogacy and reproductive assistance. Surrogacy agreements are now allowed, and they're going to be enforceable if you meet a whole bunch of requirements. A couple of the big ones: the surrogate has to be at least 21, has to have previously given birth to a child, they have to have a medical evaluation, they have to complete a mental health consultation concerning the agreement, and that person is going to have their own attorney review the agreement and be their attorney during the pendency of the agreement. The intended parents also have to be at least 21 years of age, have to have a mental health consultation, and also have their own attorney review the agreement and be their attorney during the pendency of the surrogacy agreement. There are a bunch of different requirements. Some little ones are notarization. Bottom line is, people who are going to be entering these agreements, whether as a surrogate or as the intended parents, need to have attorneys involved from start to finish, and it is a lengthy and detailed process. The second big change occurred to the APA, or the Acknowledgement of Parentage Act. Even though this act has, in its at least initial stage, been around since 1996, it was only used where the father had to go to court prior to 1996 to prove that they were the legal father. Then with the act, fathers could sign the acknowledgement and at least have standing to pursue custody equal to that of the mother. But now it's going to be applying to people not only when they're not married, and you of course don't need a court case, but it's going to be now where the biological mom and the intended parent can sign this before birth, especially in the case of assisted reproduction. It also can still be signed after the child is born, but it's going to be signed by the intended parents, typically in the case of a biological mom, and any other parent who intends to be the parent. So, also in the statute, there are big changes. It doesn't reference father and mother, but it now uses the word parent. And it changes the word from paternity and updates it to the word parentage. Except there's still an exception in it where the natural father is acknowledging paternity. Next, I want to discuss ROPA, or the Revocation of Parentage Act. Again, this year, 2025, the Act got a new name, even though the Act has been in existence since 2021. The purpose of it is intended to allow parentage mistakes to be fixed. For example, if a mom's in a serious relationship with a man, he signs the acknowledgement of paternity, now called acknowledgement of parentage, and then she later tells him, yeah, you're not really the father. Or when a biological dad finds out that he actually is the father and someone else signed the acknowledgement of paternity or acknowledgement of parentage, the biological father can go to court under this act, and it gives him standing to pursue his rights. The act also, of course, changes the terminology from father-mother and changes it to gender-neutral parent, and then paternity has been changed to parentage. A couple of the little acts that are going to be less applicable is the GPA, the Genetic Parentage Act, and the Summary Support and Paternity Act, even though they were initially enacted in 2014 to streamline the process where the government, the state of Michigan, typically done by the prosecutor's office, is when they file an action when a parent receives state services and then the government, the state, wants to pursue child support. So most of the changes to those two acts is in the terminology, again, updating from father, mother to parent, etc. I also wanted to point out that as of October 2024, the state of Michigan, so when the prosecutor typically pursues child support on behalf of a mother, up until 2024, the government would also ask for, require the reimbursement of birthing expenses, known as confinement expenses, when those are paid by Medicaid. That's been eliminated. So there are a lot of changes to family law, a lot of changes for couples and for people who are using assisted reproduction and surrogates. The whole affidavit of parentage has got complete changes to it. And I look forward to seeing how this shakes down over the next months, years. Hopefully your attorney will be up to date on all of these issues. I suspect some will not be. And if there's going to be any lack of clarity, my guess is that the court system will be giving us interpretations as to anything that's unclear. A lot of changes to be taken into account. Until next time.